Most agents think of the TDS as a summary, something to deliver, something to move past, a mandatory requirement that confuses their client, both buyer and seller. But courts see it in a different way. The TDS isn't a recap, it's a representation. And when something goes wrong after closing, it's often the first document attorneys pull. Today, we're talking about why treating the TDS like a checklist is one of the biggest risk exposures in a residential transaction. Welcome to Disclosures and Consequences. What happens when the fine print gets ignored? I'm Jason Piske, a California realtor and real estate risk specialist. Each episode, we break down one disclosure, one oversight, or one real-world scenario that can derail a deal or come back long after closing. No hype, no sales pitch, just the parts of real estate we're all expected to understand, and the consequences when we don't. Today, we're talking about the Transfer Disclosure Statement, or TDS. The Transfer Disclosure Statement was never meant to be a convenience document. It's a statutory disclosure designed to capture known facts, observations, and conditions about a property from the seller's perspective, with agent participation baked in. However, according to California statute, the listing agent is not allowed to help the seller fill out the document. Agents that do are absolutely exposing themselves to undue risk and potential litigation if something goes wrong. The problem is that in practice, agents that don't assist tend to treat it more like a formality and may not even review it when completed. They end up relying on a transaction coordinator to ensure the boxes are checked, but not what boxes. Sellers rush through it, often confused by the wording and what's being asked. Agents skim it. Everyone assumes inspections will just catch anything important. But legally, the TDS stands on its own. It doesn't disappear just because inspections happened. No matter what role you play, the buyer, the seller, or the agent for either side, the TDS is something that needs to be treated with all due seriousness and honesty. This is where things start to unravel. Sellers answer questions based on memory. I think that was fixed. I don't remember any issues. That was before we owned it. And agents, especially experienced ones, don't always slow that down or ask follow-up questions. But when a buyer later discovers a problem that was arguably knowable, the question becomes, was this disclosed accurately? Attorneys don't ask whether the seller meant to misrepresent something. They ask whether the disclosure was complete and reasonable given what was known at the time. And that's where phrases like, I didn't think it mattered, or the seller said it was fine, fall apart very quickly. Even when it's a seller that never lived in the house, some things are easily verifiable. And if you are the agent representing either side, you have to be reviewing what was checked and asking for more clarity. Catching it early and potentially having the seller redo this document may seem extreme, but trust me when I say a perceived inconvenience on the seller to refill this document can save a potential litigation later that could implicate both agents as well. The biggest mistakes I see with the TDS aren't dramatic, they're subtle. Boxes checked without explanation, unknown used instead of clarification, past issues marked as resolved with no documentation, agent visual observations ignored or underplayed, and if something later contradicts what was implied, that's where liability creeps in. I've seen failures to disclose noise issues when the house was less than 100 yards from an active railroad track. I've seen a failure to disclose that an electrical substation was adjacent to the condominium property. and improper disclosure of 220 power and whether the water heater is gas or electric. These may seem minor, but if they were discovered after the close of escrow, the buyer could always find an attorney and file suit and drag both agents into asking a lot of questions about why neither one saw it. The safest approach is simple but not fast. Treat the TDS like a risk document, not a summary. Slow the seller down. Ask follow-up questions. Encourage explanations instead of check marks. If something feels unclear, assume it needs more clarity, not less. The goal isn't perfection. The goal is reasonable transparency. I recently saw a disclosure that stated, waste disposal system repaired. Did that mean the garbage disposal in the kitchen? Or was there a problem with the plumbing in one of the bathrooms? The answer could have had bigger implications and additional inspections involved. The listing agent hadn't asked for clarity initially. Fortunately, it was just the garbage disposal being replaced, and the deal closed on time without any additional follow-up or inspections. But that ambiguity could have gone either way. Ultimately, the TDS isn't dangerous because it's complicated. It's dangerous because it's familiar, and familiarity is where shortcuts live. Thanks for listening to Disclosures and Consequences. If you want more breakdowns like this, you'll find related resources linked in the show notes. And remember, it's not the paperwork, it's the consequences.